As we have seen over the past few years, the Endangered Species Act has played an increasingly larger role in environmental law and the federal permitting process for infrastructure projects, including renewable energy development. Kerry, how is the ESA structured to protect listed species?
The ESA provides broad protections for species that are listed as threatened or endangered. And in the US, there are over 1,500 species that are listed, including birds, mussels, fish, insects, and the list continues to grow. And the ESA prohibits take of listed species without federal authorization. And take is pretty broadly defined to include harassment and harm. So it can include things like noise or vibrations from construction impacts, operation of wind turbines, or tree removal associated with right-of-ways.
What should project proponents understand about the ESA and how it affects the permitting process?
The rubber hits the road when you have transmission lines and pipelines and other similar projects that impact listed species or traverse designated critical habitat. In those cases, the projects will need authorization from the Fish and Wildlife Service and/or National Marine Fisheries Service for potential take of species.
From our experience helping clients navigate this process, we know that obtaining permission from the federal government for projects that may impact species is much more complicated than simply walking down to your local fish and game department and purchasing a fishing license.
Yes, that's right. So if your project will potentially take listed species or impact critical habitat, you will likely have to go through one of two complex regulatory processes to get authorization. First, if your project involves another federal authorization, such as an Army Corps permit to impact wetlands, you can get take authorization through consultation between the federal agency and the wildlife agencies under Section 7. Otherwise, the applicant can apply for an incidental take permit under Section 10. But either way, the project proponent is likely going to have to spend a lot of time and resources developing support for that request and proposing mitigation and/or conservation measures to offset the proposed impacts.
Now, even where a project has obtained authorization from FWS or NIMS pursuant to Section 7 or Section 10, they still face litigation risk. How do opponents use the ESA to slow down or halt these projects?
Project opponents tend to focus on ESA, particularly for renewable energy projects and infrastructure projects that may not have a lot of other federal authorizations associated with them. So in those cases, opponents can challenge the federal authorization, whether it's a FERC certificate or a BLM right-of-way or the incidental take permit itself, and argue that the government has not adequately considered impacts to species. So, for example, we've seen this recently. Environmental groups challenged a 225-mile Nebraska transmission line and wind turbines, arguing that the government has not adequately looked at impacts to the endangered whooping crane. We've also seen this come up in 2018. The Fourth Circuit invalidated a take permit for the Atlantic Coast natural gas pipeline because it found that the Fish and Wildlife Service didn't adequately set take limits for 5 species that would be impacted. So opponents often use the ESA as a federal hook, particularly for renewable projects and infrastructure projects, and it's really important for the project proponents to be very involved and work with the agencies to develop a strong administrative record that will support those permitting decisions and the take authorization.
What have you seen as the recent trends in ESA law, and are there any efforts underway to improve the permitting process?
In terms of improving the permitting process, the services are finalizing rules to revise the listing and critical habitat designation process, as well as Section 7 interagency consultation procedures. When finalized, those regulations will likely help improve and streamline the permitting process. I think there's also a common misconception that this administration is not listing species or designating critical habitat, but the ESA requires that the government respond to petitions to list species or designate habitat and allows for lawsuits when the government misses those deadlines to respond. So even though perhaps at a slower rate, this administration has continued to list species and designate habitat.
So it sounds like the continued expansion of infrastructure for renewable energy projects will keep ESA issues at the forefront of environmental law for many years to come.